right, so we'll move on to another one.
Yeah.
And especially here in Florida, it's a phrase that's passed around pretty commonly, and it's homestead. So I think first it'd be great if you can kind of let everyone know what homestead is, because everyone thinks it just always refers to the house, and we pay less taxes, property taxes, because it came homestead. But I think there's a lot more to it, and so I think giving that basic understanding would be great there.
Yeah, so I would say homestead is a monkey wrench in estate plans. I think there's a lot of attorneys that really don't fully understand how it works, and non-attorneys are really at a disadvantage as to some of these rules. So big picture, 3 things you got to know about homestead. 3 things. Number 1, and this is probably already know this. Number 1, asset protection. Your house is sacred. It's your castle. Nobody's taking away from you, with few exceptions. Some of those exceptions are you don't pay your taxes, you remodel your kitchen, and then you try to rely on the asset protection benefits and say, I'm not going to pay you. That can result in what's called a construction lien, and they can definitely put a lien on your house and sell your house. But other than those exceptions, a few exceptions, nobody's taking your house away from you if it's homestead. And now it doesn't have to be filing anything to be homestead. It doesn't have to be declaring it homestead. If it's your primary residence with a couple of qualifications, it's your homestead, and it's exempt from creditors. Number 2, there is that tax benefit that you mentioned. Tax benefit is you got to lean forward because your hair is disappearing.
I'll sink down.
And you have beautiful hair. You gotta let them see it. Number 2 is the tax benefits. It's real estate taxes. It manifests itself in 2 ways. Number 1, there's like a slight haircut on the value in which your property is appraised for real estate tax purposes. Yeah, there you go. So there's a slight haircut on the total value appraised and assessed. Number 2, your real estate taxes that are assessed each year cannot go up by a certain amount. They're capped. The millage rate is capped. So for an example, if you have a house that's like identical and you buy it today, and the person next door has the same house and they bought it 30 years ago, your taxes are going to be based on today's value, which is presumably double the value of your neighbor. Your neighbor's taxes kind of inched along over that time. They might be double the value of the taxes. Same house, same value.
Typically gets a sticker shock after the first year.
Yeah, it's not pleasant. It's not pleasant. And so if it's not your primary residence, it's a rental property, you don't get that protection. And so your real estate taxes will probably go up every year substantially. Don't mess with homestead though. It's a crime if you play games, and they can figure it out. They're smarter than you think. So don't play games. The third thing that is important to understand, I think is the biggest in my world, is the most commonly misunderstood, is the inheritance rules when it comes to homestead. Basically, the homestead is designed to stay in the family, whether you like it or not. If you're married and you have no minor kids, you can do a prenup or a postnup, and you can not give it to your spouse. But if you don't have a prenup or a postnup, you have no kids, your spouse is getting that property whether you like it or not. If you try to give it to someone else, so if I give it to Chad instead of my wife's still going to get it, but she's going to get it in a different way that I probably didn't think of, called a life estate. There's now new rules on making elections, but we're not going to get into that. Bottom line is that if you have a spouse and you have minor kids, they're going to get the house, whether you like it or not. And if you deviate from the rules, it's going to go to these people in some way with a life estate, or they can make an election. So there's a lot of limitations on what you can do with your planning, and you need to know the rules so you don't run afoul of them, which really will throw a monkey wrench in.
I think you got a good segue there, in terms of the spouse and maybe not the spouse not receiving the house. Obviously that refers to the house, but what happens, 2 people are married and one spouse tries to really disinherit the other spouse, not leave anything to her in terms of other financial assets. Is there any recourse for that surviving spouse? And how does that work?
So you're asking about disinheriting a spouse.
Yep.
If you want to disinherit a spouse in Florida, you have to move to Georgia. Georgia, I believe, is the only state where you can disinherit your spouse. Florida and New York, where again we have an office in Long Island, are states where your surviving spouse has a right to a minimum of the estate. The minimum in Florida is 30%. It's actually really interesting. It's called the elective estate. Elective, it makes sense. Your spouse has a right to elect to take what you gave her or him in your estate planning documents, or elect more if you were not very nice and gave him or her less. So say you give your spouse 50%, half. They're not going to elect 30%. At least I don't think they would. Maybe they would. Say you gave your spouse 5%. Well, maybe now they might
line up for the right advisors. They wouldn't.
Yeah, like that's not smart. So they might elect to take more because they can. Now, what's interesting about it is that the elective estate, a lot of new rules on this. The elective estate is bigger than the probate estate. So probate's like, is it in your name or not? Black and white.
Bigger meaning more stuff can come into it.
Yeah, exactly. So the elective estate is like a laundry list, a long laundry list of things that are included in the elective estate. The first one's a probate estate. Then they add a bunch of things that are not probate assets, like certain kinds of life insurance, things that pass directly to the person outside of court actually come back in for purposes of computing the value that the surviving spouse is entitled to when they make an election. It's very interesting what's included, what's not included, how it works. There's very strict timelines on this, so you really got to be careful. But the point is that you brought it up. Surviving spouses have rights.
I brought it up because it's on the list.
Okay. Don't take credit then. Don't take credit. So yeah, I think it's an interesting area. We get those questions a lot. So, number 9.
One thing that everyone could probably see is that everything is really integrated. All this stuff really kind of works together.
Yeah, it's a lot of moving parts. I like to call it a Rubik's Cube, because when you're talking about like thoughtful estate planning, you're thinking of, probate, tax, family law, inheritance law, asset protection, and guardianship, practicality, a lot of moving parts, and everybody has different goals. So it's a lot to think through. But the bottom line is that, failure to think through these things is going to result in surprises. Could be unpredictable, could be expensive, could be a lot of court. And there could be tax consequences like you saw with the IRAs. If the exemption comes down, you could be paying 40% to the government above the threshold, which 20 years ago was $1 million.
Yeah.
I mean, imagine that, So it's a lot to juggle. It's definitely a complicated area of the law. We don't recommend doing it yourself. Not for self-serving reasons, other than the fact that I get paid a lot of money to clean it up all the time. And it's very sad to see the families dealing with that.
Haimo. Hey.